Suspended Public Protector Busisiwe Mkhwebane has lost her legal bid to return to work. The High Court says a ruling to declare her suspension unlawful must first be confirmed by the Constitutional Court. For more on this, we're joined by Clarisa Vermaak, associate at Ulrich Roux and Associates. Clarisa, good afternoon and thank you very much for your time. So in this particular matter, the court has essentially reiterated its position that its ruling has no independent existence but is conditional upon confirmation by the Constitutional Court. What did you make of that judgment?
Well, I think it's a completely sound judgment and that the court is well reasoned within its judgment. It's common knowledge and common cause that any decision involving or made by the president should be confirmed by the apex court, being the Constitutional Court. And as such, the ruling made by the Western Cape High Court on Tuesday is completely sound.
So what could have been the confusion? Because they were of the view, at least Ms. Mkhwebane's legal counsel was of the view, that the appeal by the Democratic Alliance as well as the president later on allowed for them to push for the execution of the order or for her return to office in the interim.
It's very clear that they were under this impression. I do think that they were more focused on what Section 18 of the Supreme Court of Appeals Act, what the Superior Court Act provides, which provides that the Superior Court Acts provide that in exceptional circumstances, the operation and execution of a decision, which is subject to an application of appeal, is suspended. And in fact, they should have been more focused on what the Constitution says. The Constitution being the supreme law of our country, and that is what this proves, that the Constitution is the supreme law. There's no shortcuts when it comes to it, and unfortunately they couldn't rely on an act and not comply with the Constitution in this regard.
So as a principle, any matter dealing with constitutional invalidity must be heard by the Court. Now it has been clarified. But let's go a bit back now to the merits of this case. It dealt with the principle of reasonable apprehension of bias, and the court had found that though the president had the power to suspend, which we all know, in this instance he couldn't have brought an unbiased mind to bear as he was conflicted. Now that remains a very serious matter. What are the prospects of success? Do you see the Court confirming this ruling?
It's very difficult to predict that. What I can say is that the Constitutional Court will look into the factors that the High Court considered, hopefully in more depth, to come to a more concrete conclusion, specifically because it involves our president and relates to his integrity in this. If it was found that he was in fact biased in his decision to suspend her, it raises serious concerns amongst the citizens of South Africa. I know that the timing of the suspension was the High Court's biggest consideration in making their judgment, although not their only consideration. I think it would also boil down to the merits of what Mkhwebane intended to base her decision on investigating the Pala incident on. If there's concrete merit and if there was a real concern from her side, her case is obviously proven. And then also what the reasoning of the president would have been to suspend her, given that it was only a day after she announced that she would investigate the Pala incident. Both of these people hold public offices, and it is the hope of the citizens of South Africa that they both do their work and execute their job without being biased and exercising in favour. I'm very intrigued to see what the Constitutional Court rules in this case, and it's definitely something that would also set a precedent in our law going forward.
Most certainly a very, very interesting, intriguing case indeed, because when we go back to the principle of reasonable apprehension of bias, it does not necessarily mean bias exists, it's just the apprehension thereof. Perhaps you can expand on that so that we understand that in most instances it wouldn't mean, even with that particular ruling, that bias existed, but it was just the apprehension thereof.
You're absolutely correct in the statements that you're making. The apprehension of the bias that could have been existed means simply that in the face of a reasonable man or a person faced with the same circumstances that President Ramaphosa was faced with, it should be decided whether that reasonable person would be conflicted with the same apprehension, and that would be the test that suffices here. It's very true what you say, that the fact that there's a reasonable apprehension of bias does not establish that there was indeed bias. And as mentioned previously, this would definitely be an aspect that the Constitutional Court would have to consider, given that it would have a detrimental effect on the outcome of the case.
Clarisa, thank you very much for your time this afternoon. That is Clarisa Vermaak from Ulrich Roux and Associates.